an appeal in the matter of FA, Iran, and the Secretary of State for the Home Department.
May it please you, my lords and my lady, I appear on behalf of the appellant in this matter, along with my learned friend Mr. Holmes, and Mr. Wyatt appears on behalf of the respondent. This is an appeal in relation to an Iranian gentleman who sought asylum. My lord, before I actually go into the substance of the matter, could I just check with the court the papers, documentation that the court has?
Yes, but I think we have what we're meant to have. We've got the call bundle, obviously.
Yes.
We've got the authorities bundle, about which, if I may, I'll just quickly say something. I haven't checked this with my lord and my lady, but what I think anyway. It's not put together in the most helpful way. I can't understand what... There are some sections which I do understand. Within the sections, the cases aren't put in date order or any order that I can identify. And I think it's not important, but just normally they're put together in chambers these days. And I think clerks or librarians ought to be asked, ought to be given some guidance as to a sensible way of dealing with it. Also, some of them are very badly photocopied. You can't read some bits because they haven't photocopied right to the end of the page. Don't let that put you off your stroke. It's a very minor criticism, but I thought I'd better make it now while I remembered.
I'm very grateful for that, my lord. I'm also, I hope that the court has the replacement skeleton arguments for both parties as well.
I'm pretty sure I do. Certainly, yours is in the bundle, isn't it?
The replacement one was submitted on the 24th of January because it has references to the pagination of the call bundle.
Yes, that's what it's supposed to. Embarrassingly, I simply read the latest one I had and didn't spot with it, so I didn't need to follow up any of the references. But if we haven't got them, we're not inconvenienced. We probably have. Yes.
And similarly, I think there's a respondent's one that was filed on the 22nd of January as well.
Yes, the same applies.
There are two pieces of case law which is not in the authorities bundle.
Yes.
One is MA Iraq, which was brought to our attention by the court, and the other one, my lord, which my learned friend will hand up to you in due course now, is a case of IA Somalia, which deals with the issue of materiality regarding an error of law.
Yes. Thank you. Well, that's coming up.
I'll hand it up to you.
Thank you.
So, in terms of the documentation, we have all the same documentation. Just briefly regarding this case, my lord, it concerns an appellant who is 33 years old, an Iranian Kurd who left Iran illegally on the 22nd of September 2019, arrived in the UK on the 4th of December, and claimed asylum on the next day, which is the 5th of December 2019. Some of the history has been set out in the refusal letter.
Well, we are familiar with the facts, so unless there's some particular point you want to draw out, you just need to say more than you have.
If you're happy with the background to the case. In terms of the issues to be decided, and initially there were going to be 3 issues that the court were asked to consider. I am hopeful that the court were made aware that there were some developments yesterday.
Yes.
Which resulted in the fact that, so far as the issues to be decided or the grounds that we're looking at, ground 3 has been conceded by the respondent, subject to the issue of materiality. And ground 2 is no longer being pursued by the appellant. So.
Yes, that's as a result of having your attention drawn to MA Somalia. So I'm bound to say, although of course it's MA Iraq, I should say, although it has a special status being a decision of the reviewing judgment written by my lady. In fact, what she says there was all in the previous case law. I'm not quite sure why it took so long for the point to have to be conceded, but it's been conceded now.
Yes.
So
And it may be, my lord, that subject to what the court feels regarding the issue of materiality, we may not need to deal with ground one. If you are with us, if you're not with us, then we will proceed to argue ground one.
well, have I got this wrong? Forget the grounds as such. The Upper Tribunal upheld the decision of the FTT substantially on the grounds that whatever the position in front of the FTT, it was now clear from XX that the decision of the FTT was lawful.
Yes.
It's now conceded that the Upper Tribunal was wrong to do that. We're not really concerned then, are we, with the decision of the Upper Tribunal at all? But, as I understand it, you are going to say that the decision of the FTT was wrong on the basis of the country, wrong in law, on the basis of the country guidance then available. And that effectively is your ground one, isn't it?
That's ground one.
So in what circumstances would we not be arguing about ground one? The simplest way, and the most, to me, the obvious way of dealing with the issue raised by this case is simply to look at the decision of the FTT, look at your criticisms of it, and say, forget what the UT said. Do we think it was wrong in law?
I would respectfully beg to defer.
No, please do. Yes, I may have misunderstood.
Because ground three, if you're with us on ground three, because our submission is that the Upper Tribunal judge focused her decision solely upon the principles in XXPJAC. She doesn't actually engage with the argument that the First Tier Tribunal.
Exactly. So that's why we put.
Clearly,
Sorry,
if
go on.
that decision is material, if that is a material, as I understand it, if that is the case, then it is a material error for the Upper Tribunal judge not to have looked at that issue as well. So if that is the case, then the matter of materiality is such that the appellant succeeds on the basis that the Upper Tribunal were wrong in law, and the matter goes back to the Upper Tribunal.
No, we would never. Well, I may be wrong, but we would never allow the appeal because the Upper Tribunal made a mistake if we thought that the FTT was clearly right. Now, you could call that materiality. I'm not sure that's quite the right analysis. But we effectively have to do the job that the Upper Tribunal did badly of seeing whether the FTT made an error of law. We wouldn't just send it back to the Upper Tribunal to do it. We should do it ourselves. Yes, my lord and my lady agree. But isn't that how you see it?
That wasn't how I was going to put forward the case, my lord. But if you wish us to address you on round one as well, we will be doing that.
Well,
I'm going to invite my learned friend, Mr. Holmes, to deal with the issue regarding Upper Tribunal Judge Betty's decision on looking at materiality, and that would help also enlighten you in looking at ground one. So we would argue both grounds, if that is a position of the court at the moment.
well, there's obviously a complete mismatch in how we see this. But do you want to advance any arguments against the analysis I put to you? Namely, the ultimate question for us is whether the FTT was right, and that means right on the country guidance available at the time. If we are persuaded that it was wrong in law, then we will allow the appeal, not because the Upper Tribunal got it wrong, but because the FTT got it wrong.
Yes.
Why is that not the correct approach?
Could I just get Mr. Holmes to address you on the issue regarding the materiality point, because he's dealt with that in his...
Yes, very well.
Ground 3, my lord, had intended to be my wheelhouse, so to speak, so I may be able to address head-on the issue that my lordship raises. I hear the court's view as to the extent to which it might be able, so to speak, to put itself in the shoes of the Upper Tribunal. From what I gather, the court is of the view, broadly speaking, that it's just as well placed to conduct that analysis as the Upper Tribunal itself would be. The reason that the appellant would suggest that that's the wrong approach for the court to take is because, assuming that the error that has been agreed in the Upper Tribunal's analysis is material to that decision, then it must follow from that that ultimately the Upper Tribunal has never discharged its function in relation to this appeal. So in other words, the appellant is in a position whereby he would have otherwise had an opportunity to fully argue the grounds that he brought to bear against the First Tier Tribunal. But in fact, he's never had a lawful or proper decision on that from that tier of the...
So you're entitled to a decision of the Upper Tribunal, even if the Court of Appeal is in as good a position to decide. That's your submission.
It is, in a nutshell.
Can I just test that with you a bit further, if you don't mind? As I understand it, but please correct me if I have misunderstood, because I may have done. The position before the Upper Tribunal was that an appeal lies on a point of law.
Correct.
So it's not a rehearing of everything afresh. So you're certainly not entitled to have another go on the merits in front of the Upper Tribunal in general.
Correct.
First, you have to identify a material error of law. Now, suppose the Upper Tribunal has gone about its task. So if the Upper Tribunal had identified a material error of law in the FTT, then the Upper Tribunal would have gone on effectively to retake the decision on its merits. Is that right?
Or to remit it.
Yeah, all right. Leave aside remittal. So the bit that you have not had the advantage of, as I understand it, on analysis, is the bit where the Upper Tribunal would have formed its own view about the merits of the underlying appeal.
Correct.
Right. But that would only have arisen if the FTT has committed a material error of law.
Yes.
Right? Because otherwise, the Upper Tribunal has no business substituting its own views of the merits of the appeal for those of the FTT. Have I got that right so far?
Yes.
Right, so against that background, I think what my lord is putting to you is that given that it's now conceded by the respondent that the Upper Tribunal went about its task wrongly, as a matter of law, we can, in effect, put out of our minds what the Upper Tribunal was doing, and we have to ask ourselves the underlying question: did the FTT fall into error as a matter of law in any material way? Because if it didn't, then the Upper Tribunal would never have been in the business of embarking on a merits reconsideration anyway. On the other hand, you may persuade us, and we've seen the written arguments on ground one, and speaking for myself, I would like to hear those developed, because I don't know, they may be right, they may be wrong, but they're certainly all set out under ground one in the skeleton argument. And you may persuade us that the FTT did indeed err in law. So why is it wrong in principle for this court to be interested in knowing whether the FTT Erding law.
Yes. I think I'm bound to recognise the court's position. I don't think I can take the point any further than what I've already said. I'm grateful for the analysis, and I'll perhaps leave it in your hands.
Well, I think that's realistic, Mr. Holmes. Well, Mr. Wildheim, do you have a position on this? No.
Not that I need to say at this point, my lord. No, this is a second appeal. Typically, as my lord has said, you would be hearing arguments about the First Tier Tribunal decision. There is a materiality argument that we will raise in response to.
At the moment, I don't quite see how it fits in, but when we've heard Ms. Patel on ground one, and if we need to hear from you, you can explain what materiality has to do with it. Thank you. Yes.
Thank you, my lord. So far as ground one is concerned, my lord, can I take you to Judge Bannerman's decision, which is at pages 114 to 128 of the full bundle?
Yes.
And the facts as found by Judge Bannerman, and some of them were agreed facts. The fact that the appellant was an ethnic Kurd, no dispute that he was a returnee from Britain, and looking at his findings, which start at paragraph.
Can I just ask one small point about this? Neither of you were there, so you probably don't know the answer. Do you know why it took 6 months for Judge Bannerman to decide this?
No, my lord. All I do know is that the First Tier Tribunal judge did write up the decision, but then there seems to have been a delay in the promulgation of this decision.
I'd be interested to know that, because there's one or two oddities about the expression of the decision, and that may be the explanation.
If you look at page 126.
Oh, I see. Yes, I hadn't spotted that.
22nd of June is signed by the judge.
Yes, I see.
And then if you look at page 128, it seems it's been sent for him.
Yes.
He might not have put down, because this is a hearing that took place by a cloud video platform. And I think that was missing from his determination. So he was asked to do that again, but it took them 6 months to do that. And so then it was sent back.
I think you're completely right. And I'm grateful just as well I raised it with you.
Yes.
I'm afraid I looked straight to the end and didn't look carefully enough. I just saw that date. Yes. That is a date of that particular document.
Yes.
Which obviously someone thought ought to be signed.
Although it seems, if you look at page 127, the judge had approved it for
yes.
But it might have been this
126 you mean?
Missing. That's why.
Oh, I see. 122. Yes. Yes, I see.
That's why.
Well,
the delay.
no, thank you. You've resolved that. Needn't say anything more about it. I'm grateful to you.
I'm grateful, my lord. I mean, the facts as found by Judge Bannerman. The other point, I mean, the findings start at paragraph 70 onwards, which is at page 121. And the illegal exit is at paragraph 80, which is at page 123. He notes at 81, he states categorically, what is clear is that he has used social media to make posts against the government on Iran on a surplus activity. That's paragraph 81. And then he goes on also to look at the appellant's attendance as a Kurdish supporter at events, which is at paragraph 84. And he also mentions the fact that he's going to be questioned on return. That's at paragraph 95.
Before we go there, do we just need to note paragraph 85, where there appears to be recorded a concession.
Yes.
I mean,
Yes.
do you accept what's said at paragraph 85?
Yes. The concession that was made was whether the authorities would be aware of what he's done in the UK at the point that he's in the UK, not at the pinch point on return. If you actually look at paragraph 85, it specifically says the question is the pinch point has been correct. It's pinch point on return that we say he's at risk. And that's also, I think, considered at 67. Can I take you to paragraph 67 as well, my lord? This is in response to the submissions made by the representative. She was not submitting a sufficient profile at the moment, but the pinch point on return to Iran.
I'm so sorry, I missed that reference. So it's
Paragraph 67.
67, thank you so much.
Yes. I mean, that may be quite significant.
So it's pinch point on return. So the pinch point, and what is the pinch point, which is what's important.
So the concession is a relatively limited one.
Yes. So we're saying that they may not be aware of his activities whilst he's in the UK, but it's what happens to him on return that is important. And so far as the pinch point on return, country guidance cases have stated, including HB, and I was going to refer you to the latest, as a last country guidance case, which was PS Iran, my lord, which is at page, in the authorities manual, my lord, at page 384. And it's head note 4.1 that I would invite you to look at. Which says,
Just
sorry,
after
385
one
was
minute.
the head note.
Sorry, I'm behind. Where are we going? Which?
We're going to the case of PS Iran, my lord.
Yes, but where am I? Where do I find it?
Page 384. And,
Tab
384.
tab number?
Sorry.
16.
Tab 16. Thank you.
Sorry, I didn't find the tab.
And now this many authorities is always useful to have tabs. Okay, I've got it.
Head note 4.1. All returning failed asylum seekers are subject to questioning on arrival, and this will include questions about why they claimed asylum. So the appellant will be subject to an inquiry into the nature of his protection claim when he is returned, at the point of return. And so far as the country guidance case law is concerned, BA Iran looked at the attitude of the Iranian authorities towards people who've been engaged in political activities abroad. And can I refer you to BA, my lords, at page 244 of the authorities bundle, tab 13. I'm grateful.
So sorry, which tab did you say?
13.
13. Thank you.
It starts at page 244.
Yes, thank you.
But it's paragraph 65 that I would be inviting the tribunal, the court to look at, and it's at page 269.
Yes, thank you. Do you want us to read the whole of that paragraph?
Yes, my lord.
Just give us a moment then. Just remind me of the sequence of these cases. Is this... Yes, this is about 10 years previous to PS.
Yes.
And what's the relationship between PS and BA?
BA Iran is in relation to country guidance in relation to people taking part in demonstrations. PS was in relation to Christianity, but they both looked at, well, BA looked at the risk.
Yeah. Thank you very much. Yep.
And if you, regarding paragraph 65, what I would like to draw the attention of the court is, I don't know, let me just check which. It's the 11th line, it starts, my lord, with, while it may well be that an appellant's participation, do you have that?
The 11th line, yes?
While it may well be that appellant's participation in demonstrations is opportunistic, the evidence suggests that this is not likely to be a major influence on the perception of the regime, although expressing dissent itself would be sufficient to result in a person having, in the eyes of the regime, a significant political profile. So, and they go on to say that the nature of the level of the suppressed activity would clearly heighten the determination of the Iranian authorities to identify the demonstrator while in Britain and to identify him on return. So we're looking at how the authorities actually in Iran look at the police.
Don't we also have to read the next paragraph?
That's regarding facial recognition technology.
Well, it's more precise than that. It's as I understand the structure. Tell me if I've got this wrong. Para 65 is about the Iranian authorities attempting to identify demonstrators and taking it seriously when they are able to do so. Para 66 is the extent to which that information is deployed or affects how you're treated on return to Iran. And what it says is, we, at the end of the para, we conclude therefore that for the infrequent demonstrator who plays no particular role in demonstrations and whose participation is not highlighted in the media, there is not a real risk of identification and therefore not a real risk of consequent ill treatment on return. Don't we need to read that?
Yes, my lord, you do read that in conjunction with 65, but what I was drawing your attention...
But in a sense, that's the more important than 65 because it's the actual conclusion about risk on return. That's what I'm putting to you.
I'll be submitting, so far as 65 is concerned, this is concerned with the whether your activity is opportunistic or not. That is not in the minds of the Iranian authorities.
Oh, I see. Well, 65 is important, but that, in a sense, that's unsurprising. And I mean, you're right to remind us of it, but we all accept that cynical or opportunistic surplus activities can, in principle, still create risk. And that is certainly, on the evidence, the case as regards Iranian refugees,
yes,
or asylum seekers, I should say.
And the fact that dissent alone is sufficient in the eyes of the Iranian state to see someone as having a significant...
No, I do see all that. I do see all that. What I'm putting to you is that you're obviously right to refer us to that. The ultimate question is, will that feed into a risk on return? That must...
It does...
Because the Iranian authorities in London can't do anything to them.
No, it's when he's returned at the end.
Exactly. Now, that is what is addressed in para 66.
That's in relation to attendance of demonstrations.
Yes. But this is so 65.
66 was looking at not having facial recognition technology.
Yeah, but that's because when you see someone demonstrating outside the embassy, you won't know who they are. unless you can point a camera at them and use technology to identify them.
Yes, but the facial recognition itself, also if you read at 65, there's a practice by the Iranian authorities of identifying people by having spies within the people who are demonstrating.
I see that. I see all that.
Yes.
But the conclusion is what I'm trying to put to you, and I have put it to you, and if there's nothing more you can say about it, we'll move on. Are we right to proceed on the basis of the actual finding at the end of 66? We conclude that for the infrequent demonstrator who plays no particular role in demonstrations and whose participation is not highlighted in the media, there is not a real risk of identification and therefore not a real risk of consequent ill treatment on return. Is that a correct approach? I've said for us, but I really mean for the FTT.
My submission on paragraph 66, my lord, is that the risk, it looks at the risk of already being identified.
Thank you.
It doesn't deal with the pinch point.
I don't understand what you mean.
It looks at identity, as regards identity, if you read that, is looking at how the authorities are able to identify returnees who've attended demonstrations because they don't have facial recognition technology. So looking at that aspect of the case.
So is the point you're getting from paragraph 65 a wider point, which is that the regime doesn't distinguish between opportunistic and genuine manifestations of dissent?
Yes.
And that in turn means that if on return they ask him about his Facebook profile and have a look at that, they're not going to distinguish between opportunistic and genuine.
Yes.
Is that your point?
Yes.
Right.
All right. Well, we haven't got there yet.
No. No. Against the background that we're looking at, now we look at the HB Kurds, Iran, which is the other country guidance case, which is authorities bundle at page 314.
Sorry, which tab?
15.1.
So this.
This is the
Yes.
country guidance case that
Yep.
was
Thank you.
before Judge Bannerman. And my lord, you have the head notes there at paragraphs, head note 1 to 10. We also have the actual. Would you wish me to refer you to the head notes, my lord, or to the actual paragraphs in the country guidance, which are?
Well, speaking for myself, my lord and my lady, generally the head notes are very full, so that unless there's points you want to amplify by reference to the details of the guidance, I think the head note will do.
I'm grateful, my lord. Just looking at the head notes then, at 315, it identifies that since 2016, Iranian authorities have become increasingly suspicious of and sensitive to Kurdish political activity, and that those of Kurdish ethnicity are regarded with even greater suspicion and reasonably likely to be subjected to heightened scrutiny on return to Iran. And the appellant clearly is somebody who is Kurd, who comes from a Kurdish area in Iran, and he would be subjected to heightened scrutiny on return. And then I also invite the court to look at paragraph 5, because where paragraph 4 says, head note 4 says, mere fact of being a returnee, being just a Kurdish without a passport, even a combined illegal exit, doesn't create a real risk of persecution. but Kurdish ethnicity, this is at 5, is a risk factor which, when combined with other factors, may create a real risk of persecution. So, what are the, then they refer to the other factors which are identified in paragraphs 6 to 9 below. There's no argument in this case of this appellant actually having resided in the KRI, which is in Iraq. So that argument doesn't apply to him. But headnote 7 is what I would invite the court to look at. The Kurds involved in Kurdish political groups or activity are at risk of arrest, prolonged detention and physical abuse by the Iranian authorities. Even expressing peaceful dissent or who speak out about Kurdish rights face a real risk of persecution or Article 3 treatment. And then activities that could be seen to be political, they look at the fact at headnote 8, they include being involved in social welfare and charitable activities on behalf of Kurds. And that also can attract adverse attention by the Iranian authorities. And paragraph headnote 9, even a low-level political activity or activity that is perceived to be political, such as, by way of example only, mere possession of leaflets, espousing or supporting Kurdish rights, if discovered, involves the same risk of persecution or Article 3 treatment. And then at headnote 10,
Well, I think we do need to
we
read.
carry on. Each case at 9, each case depends on the facts and an assessment which need to be made as to the nature of the material possessed and how it would likely to be viewed by the authorities in Iran in the context of the foregoing guidance. And the final headnote is the Iranian authorities demonstrate what could be described as a hair trigger approach to those suspected or perceived to be involved in Kurdish political activities or support for Kurdish rights. By hair trigger, it means that the threshold for suspicion is low and the reaction of the authorities is reasonably likely to be extreme.
Yes, thank you.
So it's a low threshold and the reaction of the authorities is reasonably likely to be extreme. Now, I would also invite the court to look at paragraphs 90, 91, 92 and 93.
In this authority.
Yes, my lord.
Thank you. Which ones did you say? In this authority? It doesn't, in my case, oh, I see, yes. Which page?
Sorry, my lord, I'm just looking at.
So I hadn't noticed.
I was looking at the wrong section. I made a note of the page number.
Is it 339?
Yes.
Sorry, that was,
Yes, 339 to 340.
Thank you. So we're 91 to 93. Can we read those to ourselves?
Yes.
Yes.
Particularly in relation to 92, the tribunal noted that the Iranian authorities are extremely sensitive to activities that are perceived to be anti-regime. And the expert evidence before them, which they accepted, was that even being in possession of a Kurdish flag.
Well, we have read this.
Yes. And it goes through the details of low-level activity as well at 93. So our submission is that in respect of the guidance, it leaves little or no scope for an evaluating assessment by a reviewing decision maker. The guidance is about as close as it's possibly to come in the context of country guidance to set out absolute propositions, absolute categories of individuals who are at risk, and factors which in of themselves can lead an appellant's case to succeed. And
Well, don't you have to go further and submit that they must lead an appellant's case to succeed?
sorry, my lord, my lady.
Well, you just said, I might have noted this incorrectly, factors which can lead an appellant's case to succeed. And what I'm asking is, might you not need to go further and say that they are factors which must lead?
Sorry, I would agree with you there. I think it would must lead to success. And just concentrating on the head notes again, I'm sorry, my lord.
Sorry, I just want to make sure you were agreeing with my lady that your submission has to be, not that it can lead, but that it must lead to a risk of persecution.
Yes.
And is it your submission that is what we should draw from this authority?
If the categories that apply to the appellant as per the head notes are satisfied, yes.
Okay, thank you.
And just going on to the head notes, where, sorry, go back to head note 7, contains two propositions. A positive conclusion that Kurds involved in Kurdish political groups or activity are at risk of arrest, detention, physical abuse. That is persecution. And secondly, it recognizes that even Kurds expressing peaceful dissent, or those who speak out about Kurdish rights, also face a real of persecution or harm. So there's no scope under head note 7 for any evaluative exercise. You're not looking into the nature and extent of a person's activities. You're not looking to whether they are particularly active. You're not looking at whether they're particularly prolific, or whether they have a minor role or not. It only looks at two things. A, you're a Kurd, and B, you have involvement in political activities, and you've expressed some support for the Kurdish cause, whether by actively involved in political engagement or just peaceful dissent.
Isn't the trouble, though, that we can't read paragraph 7 on its own, and it finds its place in the context which includes paragraph 9, which talks about low-level political activity. Once you start using phrases like low-level, doesn't that immediately require some kind of assessment of levels? In other words, questions of degree. And paragraph 9 goes on to say each case depends on its own facts and an assessment will need to be made.
I would respectfully disagree, because if that was the case, the tribunal would have put it under the same head note. These are different categories that they've put forward. If one had to interpret it and look at it in the way that my lord is suggesting, then that would have been written in that manner by the tribunal.
I mean, you could say that 9 is specifically the basic point made by 9 is that even low-level
yes.
Activity will be perceived to be political.
Yes.
And then it takes the example of leaflets. It says even possessing leaflets will mean you're perceived to be politically active.
Yes.
And the point about assessment is simply that you may have to assess the particular leaflet and see whether it is of a kind that might be perceived as political.
Yes.
So it's quite a specific area of assessment.
Yes. So you look at what the nature of the material that's being possessed. Yeah, as you said, is it a leaflet? Is it a video? Is it a stack of leaflets? Is it a book, etc. So my respectful submission is that Headnote 7 would stand on its own, and it's not to be interpreted with other headnotes. So looking at Judge Bannerman's decision, I'm going to go back now. Sorry, my page is 1142.
Sorry, which paragraph
Yes,
did you say?
it's whole bundle. Page
Yes,
114.
we have it, but which paragraph or which page?
At page 124, the judge begins to deal with HB Kurds. At
Yes.
Paragraph 87.
Yes.
Is that what you want to show us?
Whilst the judge considers and looks at HB Kurd, our submission is that he hasn't actually applied it. And that's the main argument that we have. Whilst he says, I've taken into account HB Kurds, in terms of assessing the pinch point on return and assessing the actual factors as they apply under HB, he doesn't actually undertake that exercise.
May I just ask you a question on a slightly different point, please, Ms. Patel?
Yes, ma'am.
Last sentence, I think it's a sentence of paragraph 87, records his representatives accepted he didn't obtain any significant profile through that. That's what he was doing in London. Nor, though, I think it must be through his Facebook usage. And what I would just like to ask you, please, is whether the record of that concession is correct. In other words, did the appellant's representatives concede at the FTT that he didn't get any significant profile through his Facebook usage?
As I understand it, my lady, there's only one concession made, and that was set out at 67. And that was in terms of profile, to bring him to the attention of the authorities whilst he's in the UK. But it's the pinch point on return.
But I suppose that could be an ambiguous concession because, as I understand it, his activities in the UK have included going, I think, to one demonstration, one event, and also his Facebook usage.
Yes.
So would you accept that the concession about his activities in the UK must have included a concession about his Facebook usage? Or not?
I would submit that it's in relation to whilst in the UK, but not in relation to the pinch point on return, because the pinch point on return would be that they would question him, and one of the things they would question him would be about his Facebook.
Yes. What I think you're saying, if I got this right, is the concession basically means that no one in the Iranian diplomats, the Iranian embassy in London, will not have identified him, and therefore, by definition, won't have passed on his name to back to Iran. And that is whether as a result of his attending the demonstration or his Facebook usage. But you're saying that doesn't affect what the attitude will be when he's stopped at the airport and asked questions.
Yes.
When he will be asked questions about his Facebook usage, you say, and we'll
Yes.
come to the extent to which that's right. But so that's where you say the case goes, and the concession has nothing to do with that.
Yes.
Yes, thank you, that's helpful.
Because he'll be questioned on return about his asylum case, and within that he would have to say what he's...
Well, let's wait and come to that in a minute. That's quite an important point. But can I just pick up a detail? We talk about his representatives. Was he represented by counsel?
It was just... No, it was somebody from those instructing me.
Sorry?
Somebody from those instructing me.
I see. It was a solicitor from the firm instructing you. Yeah, thank you.
Can I ask you one point of detail? Because it may sometimes matter how Judge Bannerman expresses the reasoning. At paragraph 84, the judge says, in the second sentence, he did attend...
There's a Kurdish supporter.
In the UK at events,
Yes.
plural. Is that just a typo, or was there more than one event that he attended?
It was an event, a demonstration and a meeting. Meeting supporting the Kurdish cause.
I see. So there was,
At the time of the hearing before Judge Bannerman, yes.
so is it your case that he attended more than one political event?
It was a demonstration and a meeting, which he does actually outline at the beginning of his, when he's looking at the evidence.
Just give us the reference, if you would. That would be helpful.
I'm trying to remember if he's at page 40, paragraph 44. No.
Yes, because I picked up from somewhere that there was a demonstration
sorry.
and a meeting.
He's 44.
Yes, it is para 44, you're right.
Yeah,
Yeah.
yeah. That's
Yes.
very helpful. That's very helpful. You see,
Yes. Sorry, just to add to be... The demonstration, we can certainly assume... It may not matter, actually, but we can certainly assume that he was photographed. The meeting, they wouldn't know about unless they had covert representatives there.
Yes.
Yeah, okay.
And
Thank you.
if it's on his Facebook, then they'll find out on return.
Well, yes.
yeah. The reason I'm asking you this is that the most anxious scrutiny, as we all know, is required.
Yes.
And so, speaking for myself, when I apply that approach to paragraph 87 of the judge's decision, he now seems to refer, and I don't want to be unfair, but he seems to refer to must accept that he has attended some event
Yes.
in London
Yes.
on the 26th of January 2020. Now,
Yes.
are you able to help us about what he's referring to there?
I think that's the demonstration.
Right.
So was the meeting on a different...
It shouldn't be referred to as some event. It's the demonstration that the appellant attended.
Was the meeting on a different date?
Yes.
Right.
I see.
Because the other possibility is that it's a typo. You meant to say some events, and you've got the date wrong. But
Yes.
either way,
Yeah, but
as my lord points out.
But in a perfect world, he might have referred to both. But a couple of paragraphs earlier, he has referred to both, or
Yes.
referred to the plural. And one can see that the attending the demonstration is the one that's more certain to have been picked up. That's another matter, obviously, whether he was identified. Yes. Okay. Right. So that's that's been helpful, but we broke off because we were exploring the concession.
Yes.
And I think
sorry,
we have
just
your
looking
position
at-
on that.
The judge's conclusions on the application of the country guidance. Starting off with paragraph 83, which which the judge recognises, the final sentence, that whilst he may not have accepted what happened to him in Iran, there is a case to consider here in further depth with regard to surplus activity and living Iran illegally.
Yeah. Well, that was a correct focus, wasn't it?
Yes,
Because that's
it
what
was. It was. We don't dispute that. But what he needed to look at is the appellant's Kurdish ethnicity, the fact that he was returning from the UK, his illegal exit, his political activity.
But he does look at. He acknowledges that he was returning from the UK. He acknowledged that he exited illegally. He acknowledged that his Kurdish ethnicity. We see that in 86 and 88.
Yes.
So he's certainly no misdirection there.
No. It's. Then we look at 95. He mentions, he acknowledges that the appellant would be questioned.
Just
So paragraph, just sorry to interrupt, Phil. Paragraph 91.
91.
He, Judge Bannerman seems to think that period of residence and the KRI is a factor in this case, but it isn't, is it?
No.
So there's a bit of a question about why that paragraph's in the determination at all. All right, thank you.
turning to this important case is a reference clearly to HB,
Yes.
although it's rather oddly written because he already has turned to it, but still, yeah.
We don't dispute that he has referred to HB and some of the paragraphs, some of the within it, but it's application of it that is our issue. And if you look at paragraph 95, as I stated, my lord, it's clear he's going to.
Can we just pick up 92? Like a lot of this, it's very clumsily written. I don't know what the problem is that it was dictated and not corrected, but it's certainly not material from our point of view.
No, I don't know whether he's referring to the appellant residing in Iran, because 91 is to do with living in the KRI, which is Iraq. So,
anyway, irrelevant.
Yes.
93. He's repeating what he said at 90, so that doesn't take us any further. And 94, you obviously that's rather confusing. That's a reference to para 92 of HB, is it? Yeah. Certainly, it's a reference we've seen. So all that is perfectly correct self-direction.
And he's accepting that he's going to be questioned on return.
Yeah.
But he says, I've already found he's not involved in Kurdish activity, and he's referring to.
So where are you reading from?
95, but he's referring to Kurdish activity in Iran. But he's saying if he's questioned and Facebook is looked at, he has two different names. But even if the appellant has two different names, it's still the appellant, in the sense that one was a nickname and one was his real name. And
yes,
this
but the judge is clearly contemplating that they would look at his Facebook, or they might look at. There's a reasonable risk that they would look at his Facebook. I agree it's not clear, but presumably, forgive me for not knowing how this is done in practice, if he has his phone with him and has Facebook on his phone, most Facebook users do, and as he says, if he hasn't deleted it, they would just say, show us your phone, go to Facebook, and then they would scroll through to see what they could find. Is that's what we're contemplating there,
Yes.
is it?
But
Another way of doing it, presumably, would be at the airport, no doubt, if they have laptops or computer terminals, they would ask for the code and go into his Facebook that way.
in relation to deletion, though, it would be my submission, my lord, that he's referring to deleting photographs, not actually deleting Facebook. If you read that sentence.
Yes, I see, but that, I dare say he is, but in a sense it doesn't matter. He's not saying, if he'd made a finding, in practice he would certainly have deleted it, so there's no risk. That would be one thing, but he's not saying that. He's contemplating that he might not have deleted it, so they will have access to his full Facebook record.
Yes.
So you haven't got to worry about that.
Yes. Yes.
The question is what conclusions he draws, having accepted that they might, by one route or another, get into his Facebook and look at it.
Yes. He hasn't.
But I'm right. That's how.
Yes.
That's how it would be done. They'd either ask to look at the phone, or if necessary,
Yes.
they would say, "What's your Facebook password?" And,
That's it.
Yep.
Yes.
Okay.
And paragraph 96. It doesn't. He says, as a return refused Kurdish asylum seeker, he will not be at risk on a relevant level. What does a relevant level mean?
Well, again, it's very badly written, but I think all he's meaning is that the fact that you are a returned asylum seeker is not in itself a risk factor, or doesn't create a risk, a material risk. That's how I read it. If you want to suggest some other reading, please do, but I don't think it's bad for you. It's a sort of neutral point. He's just saying that in itself isn't a problem. Because doesn't one of the country guidance cases say that the mere fact that you are a returned asylum seeker doesn't count against you?
Yes, I accept that.
I think that's all he's saying.
Okay.
Well,
but
try and persuade me differently if you wish, but that's how I read it.
I can't read any more into that.
Yeah, okay, well, then I think...
But 97 is where we say the judge sets out his final conclusions.
This is the crucial paragraph.
Yes, it is.
And the first few lines of it are again to do with activities in Iran. So you would say we can put that to one side.
Yes.
Because that's not the critical issue. The critical issue is activities in the UK.
Yes.
He turns to that at line 4, and he says, taking account of the very low level of what would be found on his Facebook, if he uses the correct name and returns to Iran, explaining his use of Facebook, then there will be an issue for him.
Yes.
But I do not find the hair-trigger approach of the Iranian authorities will have him subject to any form of perception that will cause an adverse action on the authority that would mean that he would meet the terms of a successful asylum or humanitarian protection claim.
And that is challenged on the basis that he doesn't give an explanation as to why it doesn't. He sees it as an issue for the appellant. There will be an issue for him. But he doesn't then explain why the hair trigger approach doesn't apply to this appellant.
I think, isn't it, that it's the very low level of what would be found on his Facebook? But
HB says low level activity would still be considered as a risk.
Or can be.
And it's actual dissent against the regime on his Facebook, which the judge has accepted what was on his Facebook account. He doesn't actually come to offer any substantive reasoning within the terms of the country guidance. That's our submission.
I know that's your submission, but you may want to look with us and take us through in detail. Certainly speaking for myself, I would be assisted with any submissions you can make about the rest of paragraph 97 and whether you say that stacks up as good reasons or not. Because that's where his reasoning is. Seems to me the critical paragraph is 97.
I agree with you there, my lord. But in relation to the point you made about a low level, the point is not about low level. The point is actually about the appellant being Kurdish and being political, which is headnote 7.
Yeah.
I understand that point. Okay, what, do you have a submission to make to us about what he says about 8 or 9 lines up from the bottom of page 125, where he says he would not be expected to lie
Yes.
about his political belief? Do you say that if he told, do you say that that's right as a matter of legal approach, that that's how we should approach it?
Yes.
So we have to imagine a man who's at the airport, detained for questioning, asked what he's been doing in the UK, and so he's got to say what he's doing, show them Facebook, and you say to you that one of the things, if he's not expected to lie, that he would have to admit is that he attended a political demonstration
Yes.
against the Iranian regime,
Yes.
and that he attended a meeting
Yes.
to similar effect.
Yes. And that the
So on your submission, I mean, what are the Iranian authorities reasonably likely to do once somebody admits that he's been doing those things, as well as what they find on Facebook?
persecutory treatment, as per the country guidance case law and Article 3 ill treatment, that's what our case would be. That's our case, my lord.
The point that I understand the judge to be making in this latter section of 97 is, I accept he wouldn't have to lie, he wouldn't be expected to lie, he'd have to tell the truth. But what is the truth? The truth is, certainly I attended these things, but actually I'm not in the least bit interested in Kurdish independence. I only did this to bolster my asylum claim. I'm not really interested. I made it all up. That would be the truth on the judge's finding.
But
And the real question on the judge's finding is, if he said that to the Iranian authorities, would they say, "Oh, right, we can see that this is pretty low-level stuff, and we see you don't actually believe any of it anyway." That, as I understand it, is the judge's reasoning in the whole of this passage.
Our submission is, irrespective of whether the appellant has created a fanciful and exaggerated interest, if you look at BA Iran in paragraph 65, which says about opportunity, even if it's an opportunity, is how the Iranian authorities, they would not accept that.
And after all, from their perspective, he might opportunistically be disclaiming a genuine interest
Yes.
in Kurdish politics.
Yes. You may say, "Oh no, I didn't do anything."
How are they to know?
Yes.
We passed over the middle section of 97, which effectively, what I understand the judge to be doing here is looking at the case of HB itself.
Yes.
And saying that his case was a lot less strong, or the grounds for perceiving him to be politically opposed to the regime were a lot less strong than those in HB's case. Can we just?
And that is not the test, though. That's
well, I don't say, but
going on to that.
If we're going to say he was wrong, maybe you're going to come back to it, but I think at some point we should just look at the paragraph. It's paragraph 114 that he refers to in particular. Are you happy to do that now, or am I taking you out of your course?
We can go to paragraph 114 now.
Well, let's do it then. I actually don't know what was the outcome.
HB case was allowed on the basis of his Facebook.
Yes.
He was.
So you're entitled to say.
Paragraph 114. It notes it's not disputed that a returnee without a passport is likely to be questioned on return. Confirming expert evidence before us and recognizing existing country guidance. And it explains what they would be asked. They had a Facebook page that would be checked. They'd be asked to log on to it and email account. That's what 114 says.
So that rather confirms what my lord was putting to you earlier on about
Yes.
what the authorities would do.
Yes.
Yeah. That's helpful.
So that's paragraph 114. But I mean,
Okay, let's
This-
just
this
read.
appellant is
Can I just read on?
sorry, yes.
So the structure is that 114 to 116 says, well, his Facebook alone is enough for
Yes.
that to be a risk.
Yes.
117 says, in fact, there's more, though it's not necessary because the Facebook alone would be enough. There are, in fact, a cluster of factors lead to significant adverse reaction quite apart from Facebook material.
Yes.
It's not quite clear what that material was. Oh, I see. It's because the contents of the Facebook posts are at 112, and they are obviously a good deal more substantial than the ones in your client's case. It's not clear to me what the other factors are, but perhaps it is to you.
I think there was also in this particular case of HB his
in
parents'
the
support
PRI.
for his parents' support for Kurdish groups.
Yes, I see.
I mean,
Oh, yes, I
those
see.
factors are described in what was
Yes, sorry. If I bothered to read the end of the paragraph, I would have seen. Yes, right.
And
So-
his own support for Kurdish rights, but this appellant is in the same. He may not have the background of the parents being supporting Kurdish groups, but he himself is supporting Kurdish rights, and
Yeah,
it's
but-
not the number of Facebook posts. It's the actual fact of the Facebook post that would put him at risk.
Yeah.
And what the judge is undertaking here is a comparative analysis and not actually looking at the country guidance.
Yeah. No. So you say it's a red herring.
Yes.
HB's case may have been particularly strong, but that doesn't mean that mine is weak.
Yes.
Yeah.
And
Well, I see that.
you look at 114 to 116, that would be another basis of allowing this appellant's case, because it doesn't actually say, oh, well, if you look at it applied it. And if we are submission that by doing that, he's actually departing from the country guidance itself, without reference to the actual head notes. And he hasn't actually stated why he's departing from that.
Can you remind me, please, Ms. Patel, whether Judge Bannerman actually, what he says about the content of the Facebook material? I can't remember whether he deals with it in any detail or not.
He notes that I'm told by my little friend that it's at paragraph 95.
It doesn't really tell us what the other people's posts are that he was forwarding.
I think he also mentions 81. What is clear, he has used social media to make posts against the government on Iran.
Yeah, so that is that's helpful, frankly, that's a lot clearer.
Because that isn't one of the points I picked up in your skeleton is that not in that paragraph, but elsewhere, Judge Bannerman appears to refer simply to him forwarding other people's posts.
Yes.
Not sure it really matters, but
Yes,
but that's wrong.
Forwarding other people's post is at, I think, 95.
So,
Final sentence.
So you say that's wrong.
Yes.
What? I'm not. You say it's wrong because it's inconsistent with 81. Why else is it wrong?
Isn't he making a slightly different point at the end of 95 than the point he's making at 81?
Yes.
Because 81 is quite strongly, I mean, I expect you would argue, in the appellant's favour on this point. Do you understand, I mean, is there a typographical mistake in the fourth line?
Of 81?
Yes.
A level of abuse?
Yeah, does he mean
Yes.
use? Does he mean use?
I think it's meant to level of use.
Yeah.
Yes.
Nonetheless, I find
But-
change of name claim.
He says it's a relatively short period of time, but if you actually look at, I think that the appellant's evidence was he started, I'm just trying to find out the evidence regarding when he started.
Well, we haven't got his evidence, have we?
It doesn't matter, my lord.
I mean, it's unsatisfactory, isn't it? A case of this sort doesn't actually set out what the posts were and what they said.
Exactly.
And that is a point that was challenged to the Upper Tribunal.
I mean, some of the points emerge from.
I mean, 45. So sorry, I didn't mean to interrupt my lady. 45, which is where he's reciting the claimant's evidence.
Yes.
It's not clear whether it's his oral evidence or from his witness statement, but it doesn't matter, it's his evidence. Just says he had been using Facebook since 2020 to show he was against the regime, and then goes on to the two names he used. But I think that's, unless you can show us anywhere else. It's only at 81 and 95 that we
Yes.
find anything about
But
the...
that's the paragraph I was going to refer you to, my lord.
Oh, I see, right, thank you.
I haven't seen any other reference other than 81 and 95 about forwarding.
I'm not sure whether it'd be right for us to look at it, but have you got in court the actual evidence? Well, you won't have the oral evidence, but have you got the witness statement and what it said about the Facebook posts?
I have the original bundle on my
Yes. Okay.
laptop.
Well, I'm not sure we necessarily need to look at it, but we know we can ask you if we decide we would like to.
If it's, I mean, I have I have the original bundle, which is before the First Tier Tribunal.
Well, that's what you were saying, but
and also some additional photographs that were submitted on the day as well.
fine.
But
Are those photographs of what was on the Facebook?
yes.
Yes, I see. Okay.
Yeah. And Judge Bannerman was aware of this argument because paragraph 67 accurately summarises the point really that you've been putting to us this morning. The submission was the pinch point is on the turn. Experts state he'd be at risk. They'd ask him about social media because he's Kurdish, require his passport. They'd then find out details of his postings.
Yes.
This would be when you're right in the wrong. That's really your argument today, isn't it?
Yes. I'm just checking, my lord, that there isn't anything further.
I think that covers the points you made in your skeleton argument, doesn't it? Unless I'm wrong.
I'll just check with my lord friend if there's anything arising. I'm grateful, my lords. That's my.
Thank you very much,
submission
Ms.
around
Patel. That's been it's been very helpful. My lord and my lady, have any? Yes, Mr. Wyatt.
before I begin, at risk of shuffling around for the entirety of my solution, I'll request a very brief 5-minute comfort break, purely for my...
No, if you want one, you should have one.
Great for my...
We'll be back in 5 minutes.
Court rise, if able. I would like to inform the court that the meeting is still going on.
Yes, we're going outside. That's fine. You a law student?
Yeah, we're the judicial assistants.
Oh, okay.
Court rise if able.
Yes, Mr. Lyon.
My lords and ladies, I'm grateful for the short comfort break. If I can begin by responding very briefly to a couple of points raised by my learned friend, and then I'll move on to deal with the substantive response to ground one. In this case, whether the appellant was at risk on the pinch point of return to Iran must be an evaluative judgment by the First Tier Tribunal judge based on the guidance given in the country guidance cases themselves, applied to the facts of this particular appellant's case as found by the First Tier Tribunal judge. It is, I submit, not the case that simply because the appellant in this particular case is a Kurd national means that he, I'm not sure if my learned friend went this far as to suggest it, but that he gets a free ride through the asylum process.
Well, she certainly didn't suggest it. Basically, the case turns on the Facebook posts, doesn't it? I won't add it. You want to make two preliminary points. We'll come back to it.
In terms of HB Iran itself, that, I say, was explicitly considered and applied by Judge Bannerman, and that can be seen in paragraph 87 of the First Tier Tribunal decision, where it's explicitly referenced. And the points arising from HB Kurds, which you've been taken through by my learned friend, I won't take you through them again, are applied at paragraphs 95 to 97 of the First Tier Tribunal decision. That's the crux of, I say, Judge Bannerman's decision. What the court needs to bear in mind when it considers this case is the two key factual findings that were made by the First Tier Tribunal. Firstly, paragraphs 85 and 87, which is a concession that the appellant did not have sufficient profile to have been brought to Iran's attention whilst he was in the UK. And that is in relation to his Facebook posts and indeed the demonstrations and the meeting that he attended. And secondly, the concession that's recorded at paragraph 97, which is that he was not involved in relevant activities in Iran.
Is that a concession or a finding?
Forgive me, my lord, it's a finding.
But so far as the first of those points is concerned, the concession,
Yeah.
do you accept that that was a limited concession in the sense that that was while he was in the UK, not at the pinch point of when he's being questioned at the airport in Iran?
Yes, but what happens at the pinch point in Iran, we say, is directly impacted by the presence that the appellant built up in the UK.
What
It's
do you
not-
mean?
it's not
You'll say,
right.
you're about to say what you mean by that.
Just because he's Kurdish when he returns to Iran does not mean that he's automatically at risk of persecution and harm.
No, I think everyone accepts that. But what's
There is
said
a
here,
threshold.
but there was more here. That's what's said on his behalf. That there were the Facebook posts and there was, for what it's worth, some attendance at two meetings or demonstration on a meeting.
And I say the simple point is that the judge took all of that into account. It's clear from paragraphs 95 to 97 of his decision, and reached a factual finding that taken together, that information was not enough to cross the threshold on the pinch point of return that would put him at risk of harm.
But I see that that's what you have to say, and obviously we have a lot of respect for the factual findings of FTT judges. But how is that finding reconcilable with the extremely, but let's call it, use the shorthand, with the hair trigger approach found in the country guidance cases? Why wouldn't the discovery of the Facebook posts, annoyingly, we're not told exactly what's on them, but they clearly show political dissent and attendance at political demonstrations. Why wouldn't that be enough to trigger the hair trigger? Judge says, oh, it wasn't. But why wasn't it? Completely unreasoned finding. If you're going to say something, if you're going to say something which on the face of it is contrary to the country guidance case, the least you've got to do is give some reasons.
Because what is clearly found at 81 is that the appellant used social media to make posts against the government. It says of Iran, but I think he must mean of Iran. So you have a clear finding there that the posts are against the government.
My lady, I can't assist you with what was in the Facebook post. I wasn't there and I haven't had sight of them.
No, we have to work with the findings we've got.
And I say that the point, although I have to accept it's not fully reasoned in the decision, although this isn't a reasoned challenge brought by the appellant, is that the judge must have reached an evaluative finding based on having had sight of those posts, which in his judgment didn't cross that threshold. Yeah. I accept it's not necessarily expressed particularly well in the decision. That is the logical inference, I say.
Yeah, I see that. Thank you.
What I had intended to do, my lord, was to take you through the country guidance case law. My learned friend has done that. I was intending to take you through each of the paragraphs of the decision and apply it. But clearly, by the time I've got on my feet, you've had all of that done by my learned friend. I don't want to...
We won't criticise you at all, Mr. Wyatt, for going straight to the point. There may be not a lot you can say, by which I don't mean not a lot you can say on the merit, but maybe the point's very stark. It's a judgment simply about whether Para 97 is an adequately reasoned departure, or departure is perhaps begging the question, adequately reasoned conclusion in the light of the country guidance authorities to which we've been taken. And anything you can say on that obviously would be important and helpful, but again, it's only a few lines, so there isn't a great deal.
Well, I'm not sure I can really take it any further other than to say that you, my lord, lady, know what the country guidance says. It's clear, I say, on any reading of paragraph 97, that country guidance has been applied to the facts of this case.
Yeah. Well, that is succinct, but it may well be appropriately succinct.
May I just ask you about the HB head note? Because we did have some discussion about how one reads paragraph 7. Is it HB I'm thinking of? I would just welcome your submissions on that for the Secretary of State.
I can't read, my lord, paragraph 7 in isolation. It has to be read in context of the rest of the head note.
Forgive me, can I just get that in front of me?
It's on page 315, tab 50.
What's said against you is that paragraph 7 is a freestanding proposition, and that if you apply that to the facts of the present case, it's pretty obvious what the answer is. This man qualified. I think that's what's said. But do you have a submission to make to us about how we should read paragraph 7?
I, my lord, would disagree and say that paragraph 7 needs to be read in context of HB as a whole, and also the other country guidance, including BA. What I say is that when you read BA alongside the head note of HB, what the country guidance tells us is this, which is that the analysis of risk is case-specific one, taken into account the individual facts of the case, but having regard to those facts in light of HB and BA. So the fact of FA being Kurdish is simply one risk. Yes, it heightens that risk, I can't escape that. But it is only one factor in light of factors in BA that say that the other clear points we must consider are political activities in the UK, sewer class activities, as well as what happened in Iran. And when you put that together, I say the First Tier Tribunal judge came to the view that being Kurdish was one factor, but weighed in the balance, it did not cross the threshold.
I can see why you say that, and we'll have to consider what you say, of course, with care. But if one is to apply, for example, paragraph 9 by analogy to the present case, and that was expressly said to be by way of example only. So they were saying there have to be an assessment made as to the nature of the material possessed, because they were saying in the first two lines, by way of example only, mere possession of leaflets involves the same risk of persecution, or it may, at least it may do. Now, by analogy here, could it be said that if you're going to make a finding against the claimant, that you really have to set out very carefully what the Facebook posts in fact said, and then reach an evaluation, an assessment as it's put here, as to the nature of that material and how it would be likely to be viewed by the Iranian authorities? Is that a fair way of posing what the exercise is that the FTT ought to be performing?
Well, that is the exercise the FTT is performing. It may be, but in this case it's not fully reflected in the reasons for the decision. But as I say, this isn't a reasons challenge.
No.
And in any event, paragraphs 95 to 97 still give, I say, clear insight into the judge's reasoning.
Yes, I see. Thank you.
My lords, my lady, I've kept it brief. I accept
well,
that. Maybe I can't assist you any further.
May not be, may be perfectly appropriate. No? Yes, thank you very much.
My lord and lady, would you benefit from a response on that issue in particular about the head note of HB? How it is to be?
Well, I think it's not quite that way around. It's up to you whether you want to reply, and if you do, as long as it's a genuine reply to a point made, we will hear you.
Oh, very, very good. Let me say this then about the question as to how the head note of HB ought to be read. In my respectful submission, what the Upper Tribunal has done in HB, consistent with its practice in other cases, is to identify what we might say are risk categories. So the task of the First Tier Tribunal is firstly, of course, to find the facts. That's been done to a greater or less extent in this case. And then to consider whether those facts come within any one of those categories that are set out. Now, it's for that reason that we would suggest Head Note 7 can be read, and indeed should be read, as a standalone risk category. In circumstances where an individual has been involved in some form of political activity on behalf of the Kurdish ethnic group, then they fall squarely within the scope of Head Note 7. It's not necessary to go on, and the Head Note or the decision elsewhere does not suggest that it's necessary to go on to consider the other risk categories that are set out. Now, to the extent that the respondent argues that Head Note 9 provides an answer to that, the correct approach to the assessment of Head Note 9 is that which I think was postulated by my lord during argument. It's in essence a two-stage analysis. So in the first case, the decision maker must review the type of material that the individual happens to be in possession of a single leaflet or more, videos, books, so on and so forth, and then go on to expressly address the content of that material in the light of, as the headnote tells us, foregoing guidance. So in other words, if the content of that material is political, then we read back to headnote 7. And we are squarely back within that risk category.
Effectively, what you're saying is it's a particular situation in which the principles in headnote 7 may have to be applied, namely possession of materials. Leaflets is perhaps a bad example. It's hard to think of, I know it's the one they mentioned, hard to think of a leaflet that isn't political. I mean, I suppose it could be come to a Kurdish supper, or evening of Kurdish cinema or something.
Yes.
Yes, I suppose that would be an example. Or a novel, maybe, set in contemporary Iran. You'd have to see whether it was just a love story or whether it actually had a political content, and so on. That's the sort of exercise you have to do. But I think you would say, as soon as it has any politics in it, then 7 and 10 apply.
Correct.
Yeah.
Correct. And the one final point that may assist in your analysis of headnote 9 and what the Upper Tribunal meant there is to visit the substantive reasoning that they give in the body of their determination.
Yeah.
I think you've been taken there already. It's paragraphs 92
Yes, we have.
and 93.
Yeah.
And they expressly address there the criticism that was made by the respondent at that hearing of the example being given of mere possession of a single leaflet. So that's what then goes on to inform what's said at headnote 9. Unless there are any further matters in particular, I can address you.
May I just ask you at a point that Mr. Bayard made towards the end of his submissions, when he pointed out that this is not a reasons appeal.
Yes.
On your submission, what should this court do? If we have no concluded view whatsoever, but if we thought that paragraph 97 in the judgment of the FTT was deficient in some way, on your submission, what ought we to do?
The appropriate outcome or disposal for the appeal, I think I'm bound to accept, would probably be for this court to uphold certain of the factual findings and also certain of the risk assessments. So, in other words, what I'm getting at is the conclusions as to events in Iran, for example, which are unchallenged, and the lack of any risk that will flow from that. There may be an open question as to the extent to which the First Tier Tribunal's other findings of fact can be preserved. Because amongst other things, as has been observed during argument today, they're not entirely clear in a number of places. The determination as a whole is not, I respectfully say so, particularly clearly written. But also there are certain findings which are absent. One of the observations made from the bench has been about the lack of clear findings on the content of the Facebook evidence. We know in broad terms that it was political. We don't know from the judge's findings much more than that. So the ultimate, I think, answer to my Lord's question is that it may be necessary to remit that half of the case. So the findings of fact in relation to surplus activity and the consequent risk assessment.
It's very helpful. It's implicit in that answer that you're not inviting this court, even if otherwise we agree with you, simply to substitute our own view for that of the FTT and say that the underlying asylum claim succeeds.
Forgive me. I didn't mean for that to be implicit.
All right.
Perhaps spoken a little bit too quickly without fully thinking through my response. The broad thrust of my learned friend Miss Patel's submissions at the outset were to identify certain settled findings of fact, which we say are enough to lead this case to success. So, if you forgive me for backtracking slightly on my earlier response, it may well be open to this court if it takes the view that those findings are sufficient for its purposes to apply the country guidance to conclude that in essence there was no other conclusion that the First Tier Tribunal could have reached. And that feeds into, I'll then defend Ms Patel's submission about the lack of any scope in reality for evaluation of the risk categories set out in the heading to page B.
But in the alternative, you submit it would have to be remitted to the FTT. Is that right?
For that factual finding process to begin again.
That's very helpful. Thank you.
It's probably convenient, isn't it, Mr. Wyand, if that were the route we were to take, to ask for your submissions now. First question: what's your submission on Mr. Holmes's primary position? Would you second that we should simply allow the appeal, or the asylum appeal itself, and the fallback position that we should remit to the FTT while preserving certain findings? And he wasn't very specific which, and I can understand why. I want to wait and see exactly how the reasons come out. But do you have any views about those two, any submissions about either of those alternatives?
Well, only to say that the Secretary of State's position is that it should be remitted back down to the First Tier Tribunal to preserve factual findings. As my Lord, you say, that what those factual findings are will primarily depend on what you find, but we would certainly be inviting the court to preserve the concessions that were made.
Yeah.
And the findings on surplus activities, as well as the findings about his activities in Iran.
One difficulty, I suppose, we'll have to think this through, is the position about surplus activities may have changed. Some hint at something that Ms Patel said earlier suggested that was so. Position about activities in Iran won't have changed. Very well, we'll rise for a few minutes and see where we are.
Court rise in able.
Nobody's listening to it. Let's go back out. Where's everybody gone? Huh? For you. Yes, I know. All rise if able.
Yes, well, we're grateful to both advocates for their succinct submissions, both, I should say, all three. We are going to reserve our decision. Draft judgments will be circulated in the usual way so that the parties can agree, if possible, the consequential orders, or if they can't, produce short written submissions so that we can make the orders at the time of formal hand down. Also, of course, for the purpose of drawing our attention to any typographical or other minor factual errors, there are, as you will be aware, severe restrictions on the purpose for which the draft may be circulated to anyone other than counsel and solicitors, and I won't trouble you with those. They can, of course, be found in the Counsel General for Wales decision. Thank you very much.
All rise if able.